Hello everyone, and welcome to the October 2023 episode of My PIP Monthly. As always, my name is Amber Ross Holloway and I'm a partner here at our Troy office. Our October 2023 topics include, of course, the case law update. We'll be discussing two to-be-published opinions. First up is the case of Reese v. James, and then we'll talk about Bronson Healthcare Group v. Esurance. And then up for trending topics in PIP litigation, I wanted to briefly discuss improper motions to exclude evidence, mainly regarding a recent unpublished opinion, Felipe Martin v. Geico. And this case centers around motions in limine that are really disguised or serve the purpose of more so a motion for a summary disposition, and how that's improper, and ways to get around that, and ways to exclude evidence other than going forward with trial as well. So that case is a pretty interesting one, and we'll discuss that in our trending topics section. Now, first up in our case law update is the case of Reese v. James. Again, this is a soon-to-be-published opinion that centers around MCL 257, Section 401(1), which indicates that a vehicle owner is liable for injury caused by the negligent operation of a motor vehicle accident, provided that that vehicle is being driven with the owner's consent. It also gives a look into negligence factors under the provision of MCL 257 401 Section 1. It includes gross negligence or willful and wanton misconducts, but negligence within the meaning of Section 401 does not encompass intentional torts at all, and that's what this case centers upon. Now, by way of background, there was an argument between Plaintiff Reese and Defendant James. James drove his grandmother and other parishioners in a van to their church in Detroit, where James' grandmother was the pastor. That van that James was driving was owned by the church. James was supposed to return this van to the church later that day to pick up the parishioners. Now, instead of returning the van, James went to a neighbor's front porch, drank some alcohol, and got into an argument with Plaintiff Reese and at least one other person. As the plaintiff tries to walk away, James jumped into the van and ran over plaintiff, unfortunately. James was later charged and convicted for this attack. Plaintiff sued James for negligence, gross negligence, willful and wanton misconduct. And plaintiff also sued the church under an ownership liability theory. Now, here the church moved for summary disposition, arguing that the suit was based on James's intentional act of running over the plaintiff with the van. James's intent, which the church argued was proven by his testimony, that he intended to scare plaintiff, along with his guilty plea for attempted assault with intent to cause great bodily harm. Now here, because the owner liability statute requires a negligent act, the church argued that it could not be held liable. Now, the trial court denied the church's motion, finding a question of fact because, according to the trial court, the only person who could testify with respect to James's subjective intent in the moment of the incident or in the moment of the assault was James himself, and James here claimed that he did not intend to hit or injure anyone or the plaintiff. So the church applied for leave for appeal, which the Court of Appeals granted, and here we are. Now, in reversing, the panel took note of the case of Berry v. Kep, which held that an owner could not be liable under Section 401 when the only allegation is that the driver committed an intentional tort. Although the statute has since been amended since the Berry case, the panel found that the amendment was not substantive, and the statute requires a negligent act, so an owner cannot be liable under a statute where the only allegation is that the alleged tortfeasor committed an intentional tort. Now, on appeal, the plaintiff here tried to portray James' conduct as mere negligence, gross negligence, or misconduct. The panel rejected this argument because the plaintiff's testimony described 2 attempts by James to run him over with the van. Not only that, but during his criminal proceedings, James admitted here that he was operating the car and attempted to assault Reese with the intent to do great bodily harm. Now here, although the complaint alleged negligence, gross negligence, or willful and wanton misconduct, the panel noted that it was not beholden to the labels Reese, the plaintiff, attached to the complaint, and the court needed to look at the case as a whole. But rather, in considering a motion for summary disposition, again, the court looks to the gravement of an action, which is determined by reading the entire claim as a whole. So ultimately, the panel did reverse the trial court's decision. Moving on to the case of Bronson Healthcare Group v. Esurance, again, a to-be-published opinion. Here, the Court of Appeals interprets MCL 500-3107C and 3107E. Now, as we all know, in June 2019, the legislature amended the No-Fault Act and changed the no-fault system by eliminating the requirement that all owners and or registrants of vehicles maintain lifetime unlimited PIP coverage. Now, MCL 500-3107 allows for an insured to select various coverages for PIP benefits: $50,000, $250,000, $500,000, or unlimited coverage. It's important to note that insurers can also opt out of PIP coverage entirely if certain criteria is met. Now, a little bit of background on this one. Here, the insured in this case, her name was Brandy Russell, was injured in a motor vehicle accident and was treated by plaintiff Bronson. Shortly before the accident, Esurance issued a policy of insurance to Russell with a $250,000 limit for PIP coverage. Now, Bronson's treatment of Russell exceeded that $250,000 limit, and thereafter Bronson sued, and Esurance prevailed on a motion for summary disposition based on Russell's selection of $250,000 for PIP insurance. Thereafter, Bronson appealed, and the issue in this case is whether Russell validly selected less than unlimited PIP coverage in accordance with the new statutory June 2019 mandates. Now, the Russell insurance policy came into being because Russell called Esurance in October of 2020 to purchase this policy. Esurance agent, his name was Exodus Anderson, answered the phone. During the course of their call, Russell agreed to purchase the policy with $250,000 of PIP coverage. At the end of the call, the agent emphasized that Russell needed to access her online portal to confirm her coverage selections and sign certain documents for her policy to be effective. One of those documents was later identified as what's called a PIP selection form. Now, a few days later, specifically 4 days after purchasing the policy from Esurance, Russell here was seriously injured in a single motor vehicle crash. Following the accident, Bronson provided the care that exceeded the $250,000 limit. It was actually a little bit over $350,000. Now, Esurance moved for summary disposition, arguing that the policy had a $250,000 limit. They argued that Russell confirmed her selection of $250,000 limit for PIP coverage on this PIP selection form in accordance with MCL 3107 Section C1 and C2, and that she electronically signed that form in accordance with the statute as well. Bronson, in turn, argued that Esurance had failed to present any evidence that Russell actually electronically signed this PIP selection form, and that the form that defendant relied upon in support of its claim. Bronson argued that the form merely had Russell's name electronically printed under where the signature was required. And then, according to Bronson, if Russell signed the form electronically, as Esurance alleged, it had to establish that she did so in accordance with something called the UETA, which defendant had failed to do. Now, ultimately, the court rejected Bronson's argument and granted Esurance motion, and Bronson appealed. Now, here, the Court of Appeals agreed with Bronson, mostly finding that the UETA and in turn 3107 was not satisfied solely because Russell's name was printed on this PIP selection form. So essentially the court here is saying, we agree that the UETA and the statute was not satisfied by this one signature, but the panel found that Esurance could otherwise establish that Russell had electronically signed the form. Now, in the trial court, Esurance produced metadata showing the IP address and represented that this metadata established that Russell electronically signed the form. But the panel also highlighted a second way that Esurance could prevail on remand. When Russell purchased her policy, she paid a premium for that policy, and the court indicated that under the statute 500-3107, Section C3, Esurance could establish a reputable presumption that Russell's policy had a $250,000 limit by showing that the premium Russell paid corresponded to that coverage limit. So here, essentially, this case holds that specific criteria must be met in order for selections to be valid. Otherwise, the insurer may still be responsible for unlimited lifetime benefits pursuant to no-fault reform or Section 500-3107 D4. Moving on to trending topics in PIP litigation. Again, I wanted to discuss improper motions to exclude evidence, or the recent unpublished opinion of Felipe Martin v. Geico. Now here, the Court of Appeals determined that one, plaintiff was asking for an opportunity to present testimony to prove that his claims against iSpine were admissible, and the trial court incorrectly instead ruled on the merits of plaintiff's claim. And two, plaintiff's motion for reconsideration was based upon a new piece of evidence, so plaintiff had not presented palpable error requiring reconsideration. And that second part really isn't at issue right now, and not really what the basis of this case is for purposes of improper motions to exclude evidence. But under MCR 2.119E2, when a motion is based on facts not appearing of record, the court may hear the motion on affidavits presented by the parties, or may direct the motion to be heard wholly or partly on oral testimony or deposition. Trial courts may exercise their discretion to decline the opportunity for an evidentiary hearing. Evidentiary hearings are not as common as one may think, but they are a unique tool that came in or would have come in handy in situations such as this. Now, by way of brief background, plaintiff here was injured after she was struck by a vehicle standing outside of his home in Detroit. The appeal primarily focuses on medical expenses incurred by plaintiff in relation to treatment received from iSpine. Now here, defendant filed a motion in limine to exclude evidence pertaining to fees incurred by plaintiff for treatment with iSpine. Defendant essentially stated that the parties intended to go to trial and that it believed that plaintiff may seek to introduce bills for treatment with iSpine. Defendant argued that plaintiff previously signed away his right to claim those no-fault benefits relating to expenses incurred from his treatment with iSpine. Now, plaintiff argued that iSpine revoked their assignment, and there goes the issue, which is the root of this appeal. Now, here, the trial court believed that plaintiff could only present that testimony regarding the revocation at trial and overlooked the fact that it could have ordered a pretrial evidentiary hearing regarding this specific issue of the assignment and or revocation of the assignment. The Court of Appeals held that the trial court erroneously and prematurely ruled on the merits of plaintiff's claim by not allowing this evidentiary hearing and excluding it based on the motion in limine. The court reasoned that the trial court ruled as if that motion in limine by defendant was a motion for summary disposition and not simply a motion to exclude evidence only. Here, the court held that granting the motion to exclude evidence constituted an abuse of the court's discretion, and that plaintiff would have been entitled to an evidentiary hearing regarding the reassignment or revocation of the claim to him from iSpine. Now, there were some other arguments. Defendant argued that the statute of fraud in relation to the reassignment of the claim to plaintiff from iSpine, where any testimony that plaintiff may present in support of his claim would ultimately be irrelevant because all assignments must be in writing to be valid. But here, plaintiff never actually argued that the statute of frauds prevents plaintiff from presenting testimony about the reassignment of the claim from iSpine. The court addressed this argument briefly, stating that defendant here, as a third party to the assignment, cannot assert a statute of frauds defense. Now, ultimately, the court here said that without that evidentiary hearing regarding the revocation of the assignment, it would be premature for the trial court to make a substantial ruling or substantive ruling pertaining to the statute of fraud or the broader contractual rights possessed by plaintiff and iSpine. Now here, the Court of Appeals determined that plaintiff was simply asking for an opportunity to present the testimony to prove that his claims against iSpine were admissible, and the trial court incorrectly ruled on the merits of plaintiff's claim by deciding the motion in limine and plaintiff's motion for reconsideration that I talked about earlier. There was no error in that reconsideration. And that is all I have for you guys today. As always, I welcome any questions, concerns, or suggestions. Please feel free to contact me using any of the information below.